All right, so we're on the record. Jill Bong versus Douglas County School District 15, 26 CV 00462. And so first off, I want to make sure, Ms. Bong, are you able to hear me okay?
Your Honor, you're breaking up, so I'm going to close the web.
We cannot hear you, Ms. Bong. Mr. Meserow, are you able to hear me okay?
I can hear you fine, Your Honor.
Your Honor, can you hear me now?
I can hear you fine, Your Honor.
I can't hear you now, Ms. Bong. There is some feedback.
Okay, 1 second.
We can.
Okay, I'm going to go on the phone because the WebEx is glitchy.
Okay.
Okay, so I'm on the phone totally right now.
Okay. Yes, we can hear you.
Thank you.
All right. And so there's a number of different filings here. We have a motion to dismiss with prejudice. We have a motion for summary judgment. And then we have a response. And then I think, and we also have respondents or petitioner's response. There's a lot of filings here. Hold on. And then we also have, I thought there was a cross petition for summary judgment, but I'm having trouble locating that. Am I mistaken?
No, Your Honor, that was filed on April 22nd for cross
Thank you.
motion.
Oh, there it is. Thank you. Okay. And so I'll start with you, Ms. Bong. What makes sense to go first from your perspective?
Yes, I'm asking respectfully for clarification regarding the procedural posture of the cross motions. My cross motion for summary judgment was filed on April 22nd, and the respondent's ordinary or CP 47C response has not run yet. The respondent has filed a brief stating it doesn't intend to produce additional material, and if the court treats that filing as solely an opposition to continuance, then my cross motion remains incompletely brief, and fairness requires continuing this hearing until briefing concludes. However, if the court treats the respondent's filing as a formal response or as a waiver to its response period, then I request that the court explicitly acknowledge that and permit my ORCP 47C reply before deciding on my cross motion. And significantly, respondent's April 29th discovery response explicitly admits it possesses no documentation supporting its claim that Mr. Meserow had authority to represent Douglas County School District 15. There is no contract, no engagement letter, no superintendent authorization, no board approval, or no procurement records that have been produced. The district also failed to produce documents supporting the calculation, approval, or authorization of the asserted $15 fee. Under ORS 192.431, the burden to justify action under public records law falls squarely on the public body. As clearly articulated by the Court of Appeals in Bong v. Douglas ESD, mere assertions are legally insufficient. Documentation is mandatory. Here, the respondent has admitted it has no documentation. Accordingly, the respondent's motion for summary judgment must be denied. At minimum, should be continued until briefing and discovery is complete or granted in my favor on the undisputed lack of required documentation. In summary, I respectfully request the court clarify procedural posture, continue the hearing until both motions fully briefed, either deny or continue respondent's motion. I also ask the court to explicitly preserve my cross motion for summary judgment as pending or undecided until then. Thank you, Your Honor.
All right. Thank you. And Mr. Meserow?
Thank you, Your Honor. This is an extremely simple case. The plaintiff alleges that defendant did not respond to her public records request made in April of 2024, and that she was not provided with a fee estimate and that she was not provided with the documents she requested. Those are simply misrepresentations to this court, and that's why I'm asking the court to award fees at the end of this case. The record shows the district did respond to Ms. Bong's public records request within less than 24 hours, provided her a fee estimate that is eminently reasonable of $15. Ms. Bong did not pay the fee. She did not ask for a waiver of the fee. And after 60 days, as provided in the statute, the request was closed. End of story. There is no obligation to respond to a public records request where the requester does not pay the fee that is quoted. Now, the other issue that plaintiff attempts to raise is also what I would consider a fairly simple issue, which is, does a lawyer have a right to represent his client? That is not an issue that can be raised by any party. There is no doubt that I have the authority to represent my client. There is a declaration of the superintendent in the record before you that says, I represent the school district for these purposes. So, despite plaintiff's attempt to muddle the record with all of these filings and cross motions, those are the issues in the case, and they're very simple. And so we are asking the court to dismiss this case and to award defendant its fees.
And on which motion or both are you asking for that, Mr. Mesereau?
My summary judgment motion, Your Honor. I think the court should grant my summary judgment motion, deny the plaintiff's, and this case should be done with.
And Ms. Bong, your response?
My response is that the school district never responded to my public records request. Whether or not Mr. Mesereau was acting on behalf of the school district is a point of contention and factual dispute at this point. Now, Mr. Mesereau can claim that he was an attorney responding on behalf of Douglas County School District, but those documents are still lacking, Your Honor. It's kind of like, let's say the school district hires Bob's mom to be a sub. Now, a substitute requires proper authorization and documentation before that person can be a substitute teacher. Now, if that person does not have those documentation and authorizations to appear as a substitute teacher, that post assertions by the sub or the superintendent without that documentation doesn't mean that appearance or performance as substitute teacher is authorized or even legal, Your Honor. The same applies here. The school district's policy is very clear that procurement and vendor paperwork is required for all vendor services, including attorney services.
And so based on the declaration of Joe LaFontaine on March 30th, I don't believe that there's an issue in dispute here. And so I am going to grant the defendant's motion for summary judgment, and I'm going to deny the cross petition motion for summary judgment. And so, Mr. Mesereau, if you would please prepare the order.
I will. Thank you, Your Honor.
Thank you, Your Honor.
And that's going to conclude this matter. Thank you both.